Good morning.
Just want to lay out a couple detectives on a case. Just want to give you the heads up. If we could possibly call it. It's Colin McLean. I'm trying to see where on the dock. I know if you don't go by the page sheet.
Right.
I'm the same way.
All right.
He would be towards. Towards the back, Judge. Like maybe 6, 7 cases from the back.
What's the last name?
McLean.
Okay. Colin Edward?
Yes, ma'am.
Okay. Okay, good morning, everyone. My name is Judge Jackie Powell, and we're here in First Appearance Court. Just to let you know that in the courtroom, I do have the state attorney's representative. I do have an attorney from the Public Defender's Office. And I have pretrial services, confinement status, the clerk, and of course, our bailiff is here in the courtroom. Over at the main jail, there is an attorney from the Public Defender's Office, which those of you who are there who have retained the public defender, I trust that you've spoken to that attorney. Just to let you know that today is not your trial date. It's not the day when you come to plead guilty or not guilty. Today is the day when you come before the court, and I will advise you of what charges are pending, and I will make a determination whether there is probable cause for the state to detain you. If I find that there's probable cause, then the next step is that I need to determine release, bond, pretrial, however, based on your individual case. So I will advise you that if you are inclined to speak on the record today, please speak with your attorney before doing so, because everything in this courtroom is being recorded. And if you want to, at a later date, to be able to give your attorney a defense for your case, you want to make sure that you speak to your attorney before you make that decision to speak on the record. If you have a private attorney and that attorney's in the courtroom, we will give the attorney a time to speak. If you have retained an attorney that you know that you've spoken to and they said that they're going to represent you and they're not here, when I call your name and you come up, you'll let me know, okay? So we're going to start this morning with Sarah Elaine Jameson.
North Broward, Judge.
Okay, this is Pompano Beach. Is this Mr. McLawrence? Or Mr. Shade? All right, Ms. Jameson, I am going to leave you for a little while because you don't have an attorney as yet, okay? I'll recall you. All right? Thank you. Daisel Rios.
Medical reset.
Daisel Rios.
Medical reset, Your
Thank you. Brittany Florence Roll.
Bonded, Judge.
Thank you. The court does find probable cause in absentia. Stacy Krushik.
North Broward. Ms. Krushek would like to resolve this matter today, Judge.
Good morning, Ms. Krushik. You're before the court today for trespassing, one count of trespassing. You do have, you're represented by an attorney from the Public Defender's Office. The court does find probable cause. Your attorney tells me that you wish to resolve your case. Is that correct?
Yes.
Your Honor, the state does not have an offer at this time. Reviewing the allegations, it appears this is someone's private residence. It appears it's a family member. I have not spoken with the homeowner. I don't know what's going on here, so.
Okay, well, with no victim contact, Mr. Reedy, I will I will release Ms. Kruschek to pretrial release. Ms. Kruschek, no return to 5810 Northeast 19th Avenue in Fort Lauderdale.
Okay.
You must report to pretrial release services within 24 hours of your release.
Okay.
Failure to do so will result in your arrest. Do you understand?
Okay.
Thank you. Jamaica Renee Chandler.
She's here, present, Judge, approaching. Come on up, ma'am. All right. Come on up, ma'am.
Good morning, Ms. Chandler.
Yes.
Ma'am, you're before the court on one count of touch or strike battery and two possession of drug paraphernalia. The court does find probable cause, Ms. Chandler. And your bond is $1,000.
Good luck, ma'am.
Good luck.
I'll call your family right after court.
Sharia Shante Davis.
Paul Ryan, Your Honor.
Davis would like to resolve this matter today, Judge.
Okay. Good morning, Ms. Davis.
Good morning.
You're before the court today on two misdemeanor KPS for expired tag and driving while license suspended. You're represented by the attorneys of the Public Defender's Office, and the court does find probable cause. Your attorney tells me that you'd like to resolve your case. Is that correct?
Yes, ma'am.
Does the state have an offer?
Your Honor, the offer be a withhold on each count.
Okay.
Is that what you would like to do, Ms. Davis? Enter a plea of no contest and
sure.
receive no conviction on your record?
No, I don't think so.
You want to fight these charges?
No, I believe she was saying she doesn't think there is a conviction on her record. So, Ms. Davis,
I'm listening.
the plea offer is a withhold adjudication. And what your attorney is saying is that it means that no conviction on your record for these charges. Is that what you want to do?
Yes, ma'am.
Okay. So then, Ms. Davis, what plea do you enter at this time? Guilty or no contest?
I think it's no contest.
You think or you sure?
Yes, I'm sure.
Okay, so you're sure that your plea is?
No contest.
Okay, so then the court accepts your plea of no contest and sentences you to withhold adjudication and court costs. I'll do court cost on one and we'll give you 6 months to pay.
Okay. Ms. Davis, if you want to go to that CRC program, it's at 4720 North State Road 7 in Lauderdale Lakes.
Are you gonna try to get me there? Because I'm homeless, so I don't even know how I'm
Sure.
gonna get there.
Judge, would the court consider signing an order allowing Ms. Davis to be transported to the CRC Center?
I would, even though I was told yesterday, well, I guess that was from one jail to the next, but I'll sign it if that's
Okay.
what it takes. I thought
right.
that there was a different discussion yesterday about transporting, so,
Well, she would need to be transported to the main jail to be picked up,
okay,
and I'll put that in the order.
okay.
Okay.
Thank
All right,
you.
good luck, Ms. Davis.
Thank you, sir. Thank you, ma'am.
You're welcome. Nicole Joanne Livingston. Yes.
Mr. Reedy? Yes. So you're calling to make that arrangement?
Paul Ryan, Your Honor, she refused.
Well, once the order is signed, I mean, that's the way we've always done it. Once the order is signed. Do what?
Arrange for her to go to the CRC.
Yeah, I can call him.
So you might want to take a moment to call her.
Yeah, I'll give him a call right now.
Thank you.
Ms. Livingston is in Paul Ryan, Your Honor.
She refused. She went back. She didn't want to stay.
Okay. The court does find probable cause.
She has a no bond hold on count 2,
Okay.
which I advised her of earlier.
Mr. Linder, you'll tell me when you're ready, or?
Oh, I'm ready whenever
Okay.
you're on. Thank you, Judge.
So then we'll call Colin Edward McLean.
Judge, he's here at Maine, and at this time, we're going to be waiving formal reading of the charge. Come on up, sir. Oh, yes.
All right, Mr. McLean, you're before the court today, and your attorneys have waived formal reading of the charge. The court does find probable cause.
Your Honor, the state is going to be seeking a no bond hold. This is a punishable by life offense based on the age of the alleged victim. Your Honor, relying upon the affidavit, the evidence contained therein, the victim's sister, who is the girlfriend of Mr. McLean, witnessed the acts recorded on his cell phone. She was able to identify him, her sister. She also identified furniture and a blanket that was captured in the video. The video depicted the allegations that make up the offense. I would also note that a controlled call was placed to Mr. McLean, and the specific statements in the controlled call are listed in the probable cause affidavit, in which not only does Mr. McLean confess to the offenses, he names the victim by name. Your Honor, based on these allegations and the Fourth ECA's holding in Esazavi State, I do believe for first appearance purposes, there is proof evident or presumption great. I'd be requesting a no bond hold. I'd also be requesting an order of no victim contact with the alleged victim whose initials are AN. No contact with, one moment, Your Honor. The victim's sister, BN, with the initials BN, and no contact with any minors.
We would object to the court making a finding of proof evident presumption great at this stage of the proceedings. That is the highest standard of proof we have in our criminal justice system. Based solely on this probable cause affidavit, it would be the defense's position that that very high burden has not been met. We would ask the court to set bond for Mr. McLean, or in the alternative, if over our objection the court does find proof evident presumption great, we would ask the court to consider using its discretion and setting a bond for Mr. McLean. And I believe Mr. McLean would most likely be agreeable to abide by any other pretrial conditions this court felt were necessary.
Who do we have at the,
Oh, Your Honor, this is Detective Edwards from the Hollywood Police Department. She's the lead investigator in the matter. She authored the probable cause affidavit. Frankly, I wasn't necessarily planning on eliciting any testimony at this point in time. If the court feels...
I only asked because she was standing at the podium.
I appreciate it.
Okay, that's your call. I have reviewed the probable cause affidavit filed in this case, and I do find probable cause. I do find that a proof is evident, and therefore, Mr. McLean, you are to be held without bond until further order of the court. Please understand that this order is without prejudice to you. You and your attorney can file a motion to set bond in your assigned division with your assigned judge to request an author hearing. Thank you.
And Your Honor, as far as the no contact orders?
And no contact, Mr. McLean, with the alleged victims with initials AN and BN, and no contact with any minors. Thank you. Kimberly Casesa.
Judge, she's here present. She declined service of public defender.
Okay. Good morning, Ms. Casesa. You're before the court today for aggravated stalking and use of a device to facilitate felony, but the court does find probable cause. Your bond has been posted.
Your Honor?
Right.
I'm sorry, I didn't hear you, Your Honor.
Your bond, I'm being told that your bond has been posted.
Thank you.
Hold on, Ms. Casesa. There
Yes,
is,
ma'am.
there's a condition of an electronic monitor, and, I'm told that they're waiting to fit you with one,
Okay,
okay?
thank you.
Good luck.
Your Honor?
Yes.
I just want to advise, Your Honor, if you can have her come back, just because I just want to advise the court.
Ms. Casesa, can we bring her back? Ms. Casesa, yes.
Yes,
I
ma'am.
wanted to advise the court, the alleged victim is present in court. I don't, I don't know if you want to explain what's going on, just so she understands the proceedings. That her bond is posted, there's nothing the court can do.
Okay, ma'am, what is your, well, you're here. What's your name? Okay, so, today, we've determined, that there's probable cause to detain Ms. Casses on this charge. Her bond has been posted, and she will be on an ankle monitor. And then she will be going to a regular division. This is just the first appearance.
And I want the court to know also, since she's been incarcerated, she has been sending out messages to me still. I get phone calls still.
Ms. Casessa, no contact means
Yes,
directly
yes, ma'am.
or indirectly. No phone
Yes.
calls. Don't ask your friend to make a phone call. You don't try to make the call and have someone else. It's no contact. Do you
Yes,
understand?
ma'am.
All
Yes,
right.
ma'am.
Thank you.
Thank you.
Destiny Summer Barnes.
No problem.
Good morning, Ms. Barnes.
Good morning.
You're before the court for a prostitution charge. The court does find probable cause.
Your Honor, Ms. Barnes is not going to be able to make a $3,500 bond. She basically has no financial resources available at all. She has lived here all of her life. She stays with a friend. She's given me the name of a friend that I can call to come up with some money, but she does not believe he's going to be able to come up with $3,500. I'd ask the court to consider reducing the bond to $1,000. Maybe they can make that bond.
Can I get on a ward?
I wouldn't have an objection to $1,000 bond, Your Honor.
Miss Barnes is asking the court for an ROR. I don't know how the state feels about that.
One moment. Yeah. Your Honor, I would be opposing an ROR or even pretrial. Her history, well, first of all, she was just arrested 5 days before this arrest. And I was on a trespassing. Last Thursday, she got time served. Possession, felony controlled substance, prostitution last year, cocaine last year, burglary of an occupied dwelling in 2017, 364 days, prostitution 2017. In 2015, after violating probation, she went to prison for a year and a day on a felony prostitution. I'll leave it at that, Judge.
The court denies the request to ROR. I will reduce the bond to $1,000. Good luck, Ms. Barnes.
Can I get pretrial? Pretrial? No?
Standard pretrial release, the court will allow that. So the bond is not necessary.
Make sure you come back to court, Destiny.
Yes, thank you.
You will get the information from the deputy. Within 24 hours, you must report to pretrial release services. Failure to do so will lead to your arrest. Do you understand? Okay.
Yes, ma'am.
Lonnie Garvey.
It's a municipal ordinance case, Judge.
He's approaching.
Okay. Well,
And I believe Mr. McLaurin is on the phone. Oh, Mr. McLaurin just called us on the phone. He wanted to know if you could reset this matter for what time, Sue, did he say?
Just recall.
Oh, just recall.
okay.
He's gonna, thank you.
We'll
Have a
recall.
seat.
Thank you. Matthew Austin Corey.
Mr. Corey is here present, Judge, at Maine. He is approaching.
Good morning, Mr. Corey.
Good morning.
You're
I
before the
think this
court
morning.
today for two counts of trespassing on school grounds. The court does find probable cause.
Judge, in speaking with Mr. Corey, he first wishes me to ask the court if you would consider resolving this matter today, if the state has an offer.
Your Honor, frankly, I don't have an offer based on these allegations, really without talking to a representative of the school. Considering, a knife was found when he was found sleeping after breaking into a storage closet there. There's too many moving pieces here.
The court agrees. His bond is currently at $25 on count one, and no bond, so I will leave it with the $25 bond. Thank you.
Judge, I'm gonna be asking for a property order so he can have access to his property and see if he can contact his friends to post his bond.
Certainly. Travis Edward Howard.
Bonded, Judge.
The court does find probable cause in absentia. Jerome Bruce Wilson.
He's here present, main judge.
Good morning, Mr. Wilson.
Morning.
You're before the court. Count one, driving while license suspended, first offense. Operating vehicle unsafe, property, improper change of lanes, and there is a writ of arrest that's not for magistrate. The court does find probable cause, and your bond on count one is $100, and you should be going before the judge for the civil writ.
Today? It's gonna be soon. Judge, in speaking with Mr. Wilson, though, the state offense, he wishes to ask the court if you consider resolving that matter today. I don't know if the state has an offer on that.
I don't think it'll be a problem. I just was gonna pull his driving record to see. I don't know if there are priors or not, which could.
Are you able to do that now?
Oh yeah, I'm pulling it right now, Judge.
Well, if you can recall Mr. Wilson, the state just needs to review his driving record and other matters. Thank you. Yes. Thank you. He has several suspensions.
Yeah, I'm, and if you want to have him come right back up, I can make an offer right now. I see no prior DWLSs. I see a prior operating without. If he wants to resolve, the offer would be withhold court costs.
He wishes to accept the state's offer, Judge.
Yeah, there's just failures to appear. Withholding court costs?
Yeah, it'd be your first DWLS within the 5-year period.
All right, Mr. Wilson?
Yes.
As to count one only, I need you to understand that this is just on the driving while license suspended. The offer is a withhold adjudication and court costs is your first offense. And your attorney will explain to you, what you should not be doing moving forward, okay?
Okay.
So, is that what you want to do? You wish to resolve the case?
Yes, ma'am.
Have you had enough time to speak with your attorney?
Yes.
Well, then the court will sentence you to, on the driving while license suspended charge, withhold and court costs. I'll give you 6 months to pay, and it still remains that you will go to your civil judge for the writ of arrest.
Okay. Now, Judge, my only additional request is I see counts 2 and 3 are infractions. I don't know if the court would consider, in lieu of his exchange of his no contest plea resolving count 1, would the court consider dismissing the
The
infractions?
court dismisses the infractions, yes. Thank you. Theodore Alfonso Bird.
Mr. Bird is approaching, Judge.
Good morning, Mr. Bird. You're before the court for petty theft. The court does find probable cause. Is this a new charge? This is a new charge.
Yes, ma'am.
January.
Yes.
Okay. Is there
Yes, Your Honor.
restitution?
Oh, I don't think there's restitution, from what I can tell.
They got the item back? It looks like it looks like they did get the item back.
It looks like it was recovered. They apprehended him shortly thereafter.
What does Mr. Byrd wish to do?
Judge, my understanding, this is a Home Depot in which Mr. Byrd did confirm that Home Depot did recover the merchandise. He wishes to resolve this matter. We're going to be asking the court to consider resolving this case today.
Your Honor, the offer from the state would be 5 days county jail. This would be Mr. Byrd's, this would be the fourth theft he's resolved since October 17th of last year.
All right, Mr. Byrd, if you wish to resolve your case, the court is going to go along with the 5 days. Adjudication in 5 days.
Let me ask.
It's a non-custody. You always go check. My guess is I'll check, but the court's kind of nice is on this book. All you gotta do is go to document processing. You pull the information. See, there's nothing about county lines, so it's a second-degree felony. But
Judge, in speaking with Mr. Byrd, he wishes to accept the state's offer.
All right, Mr. Byrd, please raise your right hand. Do you swear or affirm to tell the truth?
Yes.
Okay, you can put your hand down. Mr. Byrd, have you,
Judge, Mr. Byrd just told me right now he changed his mind. He doesn't want to accept the
okay,
state's
then
offer.
the bond is $25, thank you.
Our only request, though, Judge, is a $25 bond. I do realize from what the state says he has priors for petty theft, but Mr. Byrd advised me he's not in a financial position to post his bond. Would the court consider releasing him on pretrial release? Will he be supervised on this offense, Judge?
And Your Honor, I just want to say, frankly, he's fortunate that this officer arrested him on a misdemeanor offense. He very easily could have charged him with a felony theft, where the standard bond would have been $750.
Pretrial release is denied at this time. Darren Antoine Brown? No. Darren Antoine Brown?
Mr. Brown, come on up, please. He's approaching.
Mr. Brown, good morning. You're before the court today for resisting officer without violence and trespassing on trespassing occupied structure or conveyance. The court does find probable cause as to both counts.
Mr. Brown does want me to ask the court if you would consider resolving this matter today.
And again, Your Honor, based on the specific facts, I don't have an offer. This is, if this case is not resolved, I'm going to be looking into investigating this matter into possible either battery or resisting with violence charges, noting that there's an allegation that he kicked a security officer in the leg and shoved the arresting officer, which caused him to need to be examined at Broward Health Center.
I did read that.
Judge,
Yes.
Mr. Judge realized that's the allegations. Mr. Brown is disputing some of those allegations, but having said that, he still wishes to, and I guess agreeing to waive his right to a trial, he still wishes to ask the court and inviting the court into plea negotiations if the court would consider extending an offer on this matter today.
Are you on probation for anything? I don't mind if we from.
The court's offer would be adjudication in 10 days in the county jail.
Let me talk to him. Judge, Mr. Brown, after much thought, he wishes to accept the court's offer.
All right, Mr. Brown, will you raise your right hand? Do you swear or affirm to tell the truth?
Yeah.
State your name for the record.
Yeah, bro.
Mr. Brown, have you had enough time to speak with your attorney?
Yeah.
Do you understand that the state has not filed the charges, so at this point in time, you're waiving your right to a trial? Do you understand that?
Yeah.
Do you understand that if you're not a U.S. citizen, you could be subjected to deportation?
Okay.
Well, it's got to be yes or no. Do you understand that if you're not a
Yeah.
U.S. citizen?
Mr. Godfrey?
What plea do you wish to enter? Guilty or no contest?
No contest. Guilty.
It's got to be one or the other.
No contest.
Okay. Mr. Brown, the court accepts your no contest plea and find that it's freely and voluntarily given. As to count one, resisting, on both counts, resisting obstruction without violence and trespassing, the court sentences you to an adjudication 10 days in the Broward County Jail. Good luck, Mr. Brown. Mr. McLawrence, good morning.
Good morning, Judge. How are you?
I'm well.
Judge, believe you have Lonnie Garvey.
I'm sorry, yes, with credit for time served, any time served. Is Sarah Jamison yours?
No, Judge. But you have Lonnie Garvey on recall.
Lonnie Garvey, okay. Thank you.
Judge, I spoke with Mr. Garvey earlier this morning. This is a municipal ordinance petty theft. The items were recovered by Publix. I think in the, but in the notice to appear, the police officer noted that Mr. Garvey cooperated and returned to the store and returned the items. And in speaking with him, Judge, he would like to resolve this matter.
What is defense looking for?
Judge, I'm hoping for a
It's a petty
withholding
theft?
judicial notice of time served. Yes, Judge. Given his cooperation, and I believe this might be his first petty theft.
Karina, what was the location? I don't have the address of the,
I do, Judge. It's the Publix located at 601 North Andrews Avenue in Fort Lauderdale, 33301.
Mr. Garvey, good morning. Can we
Press that
turn?
button, the middle button.
Good morning.
Good morning. Mr. Garvey, you're before the court today on a misdemeanor capias for petty theft, and the court does find probable cause. Your attorney, Mr. McLawrence, is here, and he tells me that you wishes to resolve the case today. Is that
Yes, ma'am.
correct?
Yes, ma'am.
The state, I will sentence you to a withhold and court costs with credit for any time served. Is that how you wish to resolve your case?
Yes.
All right. Will you raise your right hand, Mr. Garvey? Do you swear or affirm to tell the truth?
Yes.
Then put your hand down. And please state your name for the record.
Lonnie Dean Garvey.
Mr. Garvey, have you had enough time to speak with your attorney, Mr. McLawrence?
Yes.
And do you understand that today you're giving up your right to go to trial?
Yes.
All right. And do you understand that if you're not a U.S. citizen, that you could face deportation?
Yes.
Are you pleading guilty or no contest to the charge?
No contest to the charge.
Then the court accepts your plea, find that it is willing and voluntarily given, and the court sentences you to withhold adjudication, credit for time served, and there's court cost of $78. Do you need time to pay that court cost, Mr. Garvey?
Yes, ma'am. Couple of months.
Then the court will give you 6 months to pay your court costs. But, Mr. Garvey, no return to Publix
No.
at 601 North Andrews Avenue. You
I
cannot go back
understand.
there. Do you understand?
Yes, I understand that.
Okay, good luck, Mr. Garvey.
Thank you.
Judge, I have one more. It's right about, should be in the middle of your stack. It's Kevin Kersaint. He's on page 12 of the docket, and he's located at North Broward.
Yeah, I know. He also says he has a private attorney. Fellow, somebody named Texler, but I was
thought
not able to
I'd,
find that person in the Florida Bar Directory.
Mr. Kersaint, you had an opportunity to speak to him, Mr. McLaurin?
Yes, Judge. He's over in North Broward. And as the court may be able to see, he has two cases. The first count is a felony count on which he's being held no bond. And the second count is a capias on a possession of controlled substance, the controlled substance being marijuana out of the city of Fort Lauderdale. Judge, he is able to resolve count number 2 without it having a detrimental effect on count number 1. The reason being that he's already been reinstated on his on a previous capias on the felony after the commission of the of count number 2. And in speaking with him, Judge, what he told me he wanted to do was to resolve count number 2 so that he could focus on count number 1, which is the felony count.
Mr. Kersaint, good morning.
Good morning, Your Honor.
You're before the court. There's, first count is that felony capias, and then count 2 is a misdemeanor capias. It's a municipal ordinance. Have you had enough time to speak with your attorney, Mr. McLawrence?
Yes, ma'am.
And is it true that you wish to resolve the municipal ordinance case?
Yes, ma'am.
Okay.
Judge, I don't know his driving status. I didn't discuss his working status, Judge, but I was gonna ask if the court, given that it's a marijuana charge, if the court would withhold adjudication here as well. And again, Judge, I don't know his prior history either. But if the court was going to resolve, I was gonna ask if the court would withhold and take judicial notice of this, of count 2, on count 2.
Yes, good morning. My name is Brian Lee. I'm an attorney at the Public
Well,
Defender's Office. I'm here in
I'd love to know what
County.
the prior drug charges are,
Here, it says
if
that
there are
Mr.
any,
Brock is his attorney.
and I don't have.
It's Kevin Kersaint on
Is
page
Mr. Brock
12.
available?
Oh, okay. Presumptuous of me.
I don't mind. Yeah, it's just for magistrate court. He's got a violation of probation hearing tomorrow morning at 8:30 in front of Judge Shearer.
Violation of probation. I'm not on probation.
He's on page 12. No one said you're on probation, Mr. Kersaint.
Oh.
Okay, thank you so much. I'll give him a call.
Do you say he's already been to, oh, because he does have court tomorrow in the first felony case.
So, Mr. Kersaint, I don't know if you heard that. You did ask me the question about court tomorrow, and that is in your felony case.
Yes.
The court date that you have tomorrow.
Public Defender's Office in Broward County. We're here in Magistrate Court with Kevin Kersaint. He says Mr. Brock is his attorney. How you doing, Mr. Brock?
All right, then the court will offer him the withhold adjudication and court costs
I know,
as to
unfortunately, they
the
didn't sound out notice.
municipal ordinance matter.
He's got a municipal ordinance.
Did you hear that, Mr. Kersaint?
Substance.
Yes. Yes, sir.
Is that what you'd like to do?
Yes, sir.
Okay.
All right, Mr. Kersaint, can you please raise your right
He's got
hand?
a court date tomorrow.
Do you swear or affirm to tell the truth?
Yes, ma'am.
Please put your hand down. Please state your name for the record.
Kevin Crescent.
And have you had enough time to speak with your attorney in regards to the municipal ordinance matter?
Yes, ma'am.
And do you wish to resolve your case today?
Yes, ma'am.
Do you understand that you're waiving your right to a trial on this matter?
Yes, ma'am.
Do you understand that taking a plea to
Yeah,
this,
Mr. Brock.
if you're not a U.S. citizen, could subject you to deportation?
Yes, ma'am.
What plea do you enter today, guilty or no contest?
No contest.
And the court accepts your no contest plea, find that it is freely and voluntarily given. The
Yeah, he's
court
got a- he's got a court
sentences
date
you to a
tomorrow.
withhold and court costs as to count two,
Judge Shearer's courtroom in the
which is the municipal ordinance matter. Good luck, Mr. Christine.
Thank you.
Thank you, Judge.
Court costs, the court will give him 6 months to pay. Thank you. Dominic Christopher Terrell. Mr. Terrell, Dominic Christopher.
He's approaching, Judge. He's here at Maine.
Good morning, Mr. Terrell. You're before the court today for drug paraphernalia, possession of drug paraphernalia. The court does find probable cause. Mr. Terrell's bond is $100, and the court will leave it at $100.
No request at this point, Judge.
Sorry, thank you. Jason Anthony Smickle.
He's approaching, Judge. Come on up, sir.
Mr. Smickle, good morning. Mr. Smickle, you're before the court today for possession of drug paraphernalia. The court does find probable cause.
Judge, Mr. Smickle, in speaking with him, he wishes to resolve this matter. So we're going to be asking if the court would consider extending a withhold, taking judicial notice of time served on Mr. Smickle's behalf.
That would be the state's offer.
Withholding court costs.
Yes, ma'am.
Mr. Smickle, is that what you want to do? You want to resolve your case today?
Yes, ma'am.
Then, Mr. Smickle, please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
Please put your hand down. Please state your name for the record.
Jason Smickle.
Smichael. You didn't correct me before.
It's all right.
All right. Mr. Smichael, you've had enough time to speak with your attorney?
Yes, ma'am.
Okay. You understand that you're giving up your right to go to trial?
Yes, ma'am.
You understand that if you're not a U.S. citizen, taking a plea could subject you to deportation?
Yes, ma'am.
Mr. Smichael, what plea do you enter, guilty or no contest?
No contest.
Then the court accepts your no contest plea, find that it's freely and voluntarily given. The court sentences you to withhold an adjudication on the count of possession of drug paraphernalia. We'll take credit for any time served. And do you need time to pay your court costs?
No.
Then I'll give you 6 months to do so. Thank you. Good luck, Mr. Smichael. Jeremy Montgomery,
I believe he's a medical loan judge.
medical loan.
That being said, based on these charges, I have no objection to an ROR, so we don't have to pay a deputy to sit outside a hospital room.
Well, the state having no objection to ROR, the court does find probable cause, and ROR, Mr. Montgomery. Terrence Lamont Wilburn.
He's here at Maine, Judge.
Good morning, Mr. Wilburn. You're before the court for a traffic KPS, driving while license suspended. It looks like it's your second offense. The court does find probable cause. Well, is it operating without a, operating with a suspended license?
It's a DWLS. It uses some of the language from both, but it's a DWLS.
Yeah.
If Mr. Wilburn is interested in resolving the matter, the documented offer from he's not?
No, he believes his family has already posted his bond. If we could have confinement status check on it, or it should be posted shortly.
Thank you. They're checking.
Not yet.
Well, it's not showing that it's been posted yet. The bond is $500. Thank you.
Thank you, Judge.
Jorge Angeles.
He's here, present. Judge, come on up, sir.
Mr. Angeles, good morning. You're before the court today for DUI, second offense, DUI with property damage to another, attaching registration, license plate not assigned, and driving while license suspended, first offense. The court does find probable cause. Mr. Angeles, the bond on your DUI is $1,000. DUI with property damage, another $1,000. The court will not impose a bond on the traffic infractions. $2,000.
Thank you, sir. I'll call and take your family right after court. Good luck.
Jose Manuel Garcia.
He's approaching, Judge.
Mr. Garcia, you're before the court today for a misdemeanor capias on a petty theft.
Correct, Judge. And in speaking with Mr. Garcia, he wishes to ask the court if you consider resolving this case today.
Did the state have an offer for Mr.
Yes, one moment, Your Honor.
Just verifying this is not a, well, it doesn't tell me if there's any restitution
Yeah,
or anything.
I'm checking that.
Okay.
Thank you, Judge. It's not, there's no restitution, Your Honor.
Okay.
Offered via time served. No return to the Publix at 6921 West Broward Boulevard in Plantation.
Withholding court costs?
Time served. He has prior thefts, Your
He
Honor.
does have priors?
Yes.
All right. So, Mr. Garcia, the state's offer is adjudication and time served. Do you wish to resolve your case with that plea offer?
Yes.
All right. Mr. Garcia, please raise your right hand. Do you swear or affirm to tell the truth?
Do you have any children?
Do you swear to tell the truth, sir? I can't hear. Oh, you can hear?
Mr. Garcia, can you hear me now?
Yes.
Do you swear or affirm to tell the truth?
Yes.
Please put your hand down. Mr. Garcia, are you under the influence of any alcohol or drugs?
No.
Have you ever been treated for any emotional or mental illness?
No.
Do you understand that you're giving up your right to a trial on this charge?
Yes.
Have you had enough time to speak with your attorney?
Yes.
And is it your understanding that the sentence that will be imposed is adjudication and time served on this petty theft?
Yes.
Okay. Then, Mr. Garcia, what plea do you, what is your plea? Guilty or no contest?
No contest.
The court accepts your no contest plea, finds that it's freely and voluntarily given. The court sentences you on the petty theft charge to adjudication and time served. I will give you 6 months to pay your court costs. Good luck, Mr. Garcia. Johnny Lee Jones.
Paul Ryan, I believe, Judge.
Thank you. Johnny Lee Jones. Anyone at Paul Ryan? Did Mr. Oh,
Counts 2 through 13 are $1,000 each.
Is there anyone at Paul Ryan?
Is there anyone at Paul Ryan?
Johnny Jump, but he refused.
You. Okay, well, I do find probable cause.
Court to leave the bond at $1,000 then.
He is represented by the Public Defender's Office,
Yeah, I
Mr.
believe he
Regan?
is, Judge, yes.
And then the bond is $1,000. Thank you. Antoine Mack.
Conti.
Good morning, Mr. Mack.
Good morning.
Sir, you're before the court for grand theft. This is an ad charge. Ad charge, the grand theft. The court does find probable cause, Mr. Mack. And your bond is $1,000. And if you post your bond, I'm gonna tell you, no, do not go back to Home Depot. No return to Home Depot at 1195 South State Road 7 in North Lauderdale. Good luck, sir. Robert Hillsman, Robert J.B. Hillsman.
Mr. Hillsman's here present, Judge?
Good morning, Mr. Hillsman.
Good morning.
You are before the court. Also, this is an additional charge on grand theft. The court does find probable cause. Mr. Hillsman, your bond is $1,000, and I am going to tell you as well, if you post your bond or at any time later, no return to Home Depot. Do you understand, sir?
Yes, ma'am.
Good luck. Lenford Leonard Gibbons.
Mr. Gibbons is here at Main, Judge.
Good morning, Mr. Gibbons.
Good morning.
You're before the court. This is an additional charge, robbery with no firearm or weapon. The court does find probable cause.
Your Honor, Jason Goldsmith on behalf of the state. The state would ask for a $25,000 bond with the same conditions. That he has previously an ag assault. He has a petty ag assault, $50,000 bond, robbery with a deadly weapon, $25,000 bond, and no bond. Robbery.
Your Honor, he's being held no bond on a robbery with deadly weapon. $50,000 bond on an aggravated assault, and $25,000 on a bond on a strong arm robbery. And this is his MO, Your Honor. Every single one of those cases involves a convenience store where he's going, committing a robbery, going after threatening violence against clerks. And also he was given a GPS on the bondable offenses.
Okay, well, these are all under the same case. This is just an additional charge, or is this?
No, it's just, these are all separate incidents, Your Honor.
Okay. Then the court,
Judge,
yes.
I do understand. He's being held no bond, and he has a high bond on the other offenses. I believe this is an ad charge. I believe he was also here on another ad charge with the robbery in which he was ROR'd. Probably the court took into consideration that he's being held no bond and his high amounts already. He's 27 years old. Before he was arrested, he was working at McDonald's, so there's no way he's going to be able to afford with the bond which is currently set. So I just ask you to take that into consideration, determining a reasonable release conditions on this count that's here before you today.
Thank you. The court does find probable cause on the robbery with no firearm or weapon, and the bond is set at $10,000. Thank you. James Terrell.
Mr. Terrell, yeah. Mr. Terrell's here.
Good morning, Mr. Terrell.
Hey, good morning, good morning.
You're before the court today on a grand theft, and the court does find probable cause.
Your Honor, you may recall, you had Mr. Terrell yesterday for grand theft, a different alleged incident at the airport that involved the elderly woman that fell down the escalator. This is now a different incident where he allegedly stole from a juvenile at the airport. You set his bond at $1,000 yesterday. I'd ask that the court keeps $1,000 bond in place in this matter.
And Judge, nothing's changed. He's not working. There's no one going to be able to post his bond. He can't afford the $1,000, which is currently set right now. So Judge, I'd ask you to take that into consideration in determining a reasonable bond on count 2.
The court does find probable cause as to grand theft, and the bond is $1,000. Thank you. Okay, this one is Braylon Fleming. Mr.
Judge,
Mr. Fleming was here 2 times yesterday. Is there,
They had charged him.
there's other charges now?
Yes, and separate and apart from what we heard yesterday.
Okay,
But I guess we're being told he's in court, Hector?
He's in 40, I believe.
So maybe, can we reset this for the PM, Judge?
okay, so then we'll reset this for the afternoon docket. Thank you. Braylon
I'm
Fleming.
being advised by the deputy judge, he has to go to 2 different courtrooms today, 7840 and 6780.
So then we'll
So I
reset
don't know
him
if we're-
tomorrow?
I think that would make sense.
Okay, tomorrow.
Thank you.
Freddie Davis.
Mr. Davis, come on up, please.
Good morning, Mr. Davis.
Good morning.
Mr. Davis, you're before the court today for grand theft, and the court does find probable cause. Mr. Davis, your bond is $7,500.
Judge, I spoke with Mr. Davis, and right now, he's not in a position to post that monetary bond nor his family. My understanding is this is his first arrest ever. He's a registered voter. He graduated from Hollywood Christian High School in 2010. Right now, he was working at Home Depot. He's 26 years old, been living here his whole entire life. At this time, he lives with his wife. They've been married 1 year, and she's working. She works security guard, but together they're both supporting their 3 children who are in public school. He says right now his wife cannot afford the $7,500. If the state can confirm that he has basically a clean record, Judge, and this is a nonviolent offense, I'd ask the court to consider releasing him on pretrial release because financially no one's going to be able to post his monetary bond.
State, can you speak to Mr. Davis's record?
I'm pulling that right now, Your Honor. In the meanwhile, I'm pulling that up. Mr. Gold's.
Your Honor, based on the facts of this case, the state is not seeking any modifications to the bond amount of the $7,500. And also the state is requesting no return to the Paradise Jewelers. And we're also asking that based on the amount of which was stolen, which is $15,436, that the bond be kept in place.
Okay, Your Honor, answer the court's question. I see no history.
Okay. So, Mr. Davis, at this time, the court does find probable cause. I will set your bond at $2,000. No return to Paradise Jewelers. And I'm also going to add standard pretrial supervision.
Judge, I understand the court's, I guess, ruling at this time. I'd ask you at this time to reconsider. Mr. Davis told me once again he does not think his wife can afford the $2,000 bond. They're supporting their 3 kids. Christmas and New Year just over. They have the rent to go ahead and pay. There's no way he's going to be able to afford this bond. He has no priors, and he's been here his whole entire life. These are merely, at this point, allegations. So, Judge, I'm going to be asking, considering his strong ties, lack of record, this is a nonviolent offense, to reconsider and place him on pretrial release, Judge.
Mr. Romero, I'm going to deny that. Based on the circumstances of this robbery, I believe that it's $2,000 in standard pretrial release is appropriate at this time. Thank you. Mike Mateer.
Mr. Mateo, come on up, please.
Good morning, Mr. Mateer.
Yes, ma'am.
Sir, you're before the court for aggravated assault with a deadly weapon without intent to kill. Count 2, resisting officer, obstruction without violence. Count 3, reckless driving, first offense. Count 4, driving while license suspended, third or subsequent offense. And 5, attaching registration license plate not assigned. The court does find probable cause. Mr. Mateer?
Your Honor, the state is requesting a $25,000 bond based on the allegations in this case, as well as as well as 5 counts, as well as his criminal history, 5 cases that he was for 40 months at Hitchell.
Your Honor, I apologize. In 2014, he was convicted of 5 counts of criminal use of personal identification information and receiving, retaining stolen property. He was sentenced to 40 months in Florida State Prison. He was released from state prison in February of 2017. Additionally, he has 2013, false imprisonment, felony battery, domestic violence by strangulation, felony battery due to priors, culpable negligence. 2011, battery. 2008, strong arm robbery, 22 months state prison as a habitual offender. Battery, 2000. Just need to check one thing, Your Honor, to confirm this. Does pretrial show he's a registered offender? Attire. Well,
With registration or
Hi-
career or set?
high risk. Sexual offender.
I know I see the search chart from 95. I'll have to run a more thorough check.
And Your Honor, the reason I'm seeking to confirm this, one, I want to confirm it before I advise the court, but I think it's, if he is registered, it's obviously something that the court should take into consideration, not only based on the potential consequences he faces in this case if convicted, but also potential civil commitments if convicted on this offense.
Do you need me to go back to it? Okay.
Your Honor, I mean, I can advise the court. I've got a hot file alert from FCIC, which shows that Mr. Matire is a high-risk sex offender, and it was entered January 11, 2017. It has his name, date of birth, his social security number, which I confirm with the probable cause affidavit before the court.
Thank you. Mr. Matire, the court does find probable
Judge,
cause. Yes, sir.
If I may, before you make a
Yes.
ruling on the release conditions for Mr. Mateer, first, he's disputing, as far as Mr. Lender is pointing out from his records, indicating that he has to register. Mr. Mateer says I have to register. Having said that, Judge, he's 37 years old. He's been here his whole entire life in Florida. He's working right now. He works for an entertaining company which sets up stages. He's been doing that for a number of years, and he's basically the sole provider of his family. He rents a house at Lighthouse Point. Their monthly rent is about $800 per month. He supports his 4 kids. What seems to be the problem is when he was arrested, he didn't have his phone with him. So unfortunately, he has no way of contacting anyone to help post his monetary bond. So he's kind of caught here in a bad position. Judge, even if he could get a hold of someone, he does not think that they can afford very much. Judge, I do understand the allegation. I do understand that he has a criminal record. However, he's just not in a financial position to post any sort of bond. Judge, in exchange, consider looking him a minimal bond. We'd be asking the court to consider releasing him on level 2 pretrial release, so that way he can be supervised. He just needs to be on outside working, supporting his family, and he'll be looking forward to his day in court contesting these allegations.
All right, thanks. Based on the nature of the circumstance, of the arrest, surrounding the arrest, at this time, the court does find probable cause, and as to count 1, I'm gonna set a bond at $10,000. Count 2, resisting without violence, $100. 3, reckless driving, $100. And 4 and 5 will remain $750 and $25. Good luck, Mr. Mateo. Yes. 10,000, yes. Antoine Waters.
Mr. Waters is approaching, Judge.
It doesn't matter. It's just that I just have to see that it's there. I'm sure it helps to make things go fast. Mr. Waters, good morning.
Good morning.
Mr. Waters, you're before the court today on count 1, burglary of a dwelling, causing damage over $1,000. Count 2, possession of burglary tools with intent to use. Count 3 is petty theft, and then count 4 is a misdemeanor capias. The court does find probable cause.
Your Honor, even though count 1 is a PBL, I'm not gonna be seeking a no bond on count 1.
Okay,
On the PBL, I am gonna be requesting a $10,000 bond, not only based on the allegations, but also noting that Mr. Waters is out on bond right now for possession of substituted cathinones, cannabis, carrying concealed weapon, and no valid DL. Matter of fact, he actually it's mentioned in the PC that he advised law enforcement that he was breaking into this house and trying to steal copper wire to get a bus fare to go to court. I don't know how he was gonna be able to sell it that quickly to be able to get, in an hour to get the bus and then get downtown, but that's what he told law enforcement.
Mr. Romero, do you wish to be heard?
Your mic's off.
Oh, I'm sorry. $10,000, he can't afford that, Judge. He is working. He works at the Cheesecake Factory there for about 3.5 months now. He's a dishwasher, and he makes about $11 an hour. He lives in Fort Lauderdale with the mother of his child. His mother of his child right now is also pregnant, and she's basically on bed rest. Their monthly rent is about $795, so from what he advised me, she's not going to be able to come up with very much. Judge, I do understand the fact pattern, and from what Mr. Lender did say, looking at the brighter side of that story, at least he was cooperative with law enforcement and gave them additional details. Judge, I'm going to be asking the court to consider a $3,500 bond on count 1. I'd ask for the court to consider an ROR on counts 2 and 3. So we're asking for a $3,500 bond on his behalf, Judge.
The court does find probable cause, Mr. Waters. As to count 1, the court will set a bond on count 1, $2,000. On count 2, $1,000. Count 3, $100, and the misdemeanor capias remains with the $250 bond. Thank you. Christopher Patrick Clay. Mr. Clay?
Mr. Clay, come on up, please.
Clay, wake up.
All right, Mr. Clay.
Mr. Clay.
Please approach, Judge.
Mr. Clay, good morning. You're before the court today on an aggravated battery causing bodily harm. The court does find probable cause.
Your Honor, the state is requesting a $15,000 bond, and this is based on the allegations in the case, as well as the fact that he has a pending felony grand theft in 2017, in 2014, a disorderly intoxication, 2009, a DUI, in 2007, traffic in oxycodone and delivery of alprazolam, in 2005, grand theft and resisting without violence.
Judge, we're going to be asking the court to consider setting a $3,500 bond on this case. Hold on one second, sir. He's 41 years old. He's been here his whole entire life. He lives with his wife in Pompano Beach, where they've been renting at the duplex for about 4 months now. Their monthly rent is about $1,000, and unfortunately, his wife is going through a very serious illness. When she's healthy, she basically cleans for. The bad news is he just unfortunately lost his job. He was a driver for a gourmet bakery in which he was getting paid about $80 per day. Now, the case that he's currently out on, Judge, is a grand theft, and I believe it's about a 2-year-old case in which he says he's been going to court for that, and I believe he's applied with the public defender. Judge, on this case, we're also going to be asking, besides the $3,500 request, we're going to be asking for a photo order so we can photograph the injuries that Mr. Clay sustained from what he advised me as a result of him defending himself. So, Judge, we're going to be requesting a $3,500 bond on his behalf.
Thank you. Based on the seriousness of the charges, the court does find probable cause, 1, and then 2, the court sets the bond at $15,000. Thank you.
And Your Honor, the state is also requesting
No contact. And I will sign an order for the phone orders as requested by defense. The photo orders.
Thank you, Judge.
Benjamin Billy.
He's in North Broward, Judge. Mr. Billy has private counsel, Mr. Tim Cox, who would like to appear by phone.
What is the name of the attorney?
Tim Cox,
And you have Mr. Cox's number?
954
Okay.
604 3987.
3987. Good morning, Mr. Billy.
Good morning.
I understand that you are represented by attorney Tim Cox.
Yes, ma'am.
And
Yes, ma'am.
I am going to attempt to reach Mr. Cox at this time.
Yes, ma'am. Thank you.
Yes, can I help you?
Is this Tim Cox?
Yes, ma'am.
Mr. Cox, this is Judge Jackie Powell. I'm calling from First Appearance Court.
Good morning, y'all.
Good morning. I just need to tell you that you're on speaker in open court. I have before me Benjamin Billy, and I understand that you're representing him. Is that correct?
Yes, Your Honor.
Okay. So, Mr. Billy, can you hear your attorney on the phone?
Yes, ma'am, I can.
All right. Mr. Billy's before the court today on count 1, a DUI, alcohol or drugs, 4th or subsequent offense, and 2, operating without a valid driver's license. And the court does find probable cause. Mr. Cox, did you wish to be heard as to the bond?
I would, Your Honor. Just a brief argument. Mr. Billy is born and raised in Florida. His entire family resides either on the Seminole Reservation in Brighton and Hollywood. We would ask for a minimum bond. There is no threat of flight. There's ample proof in the record that Mr. Billy will appear in court and face the charges to clear his name. But we would ask for a minimum bond.
Okay.
Your Honor.
Okay,
Thank you, Your Honor. Your Honor, the state is requesting a $15,000 bond plus pretrial supervision plus a tag monitor. I'm sorry. Oh, TAD monitor. I apologize for that. No alcohol, no intoxicants, and no driving. This was a crash, and the defendant's driver's license was permanently revoked, and we believe that he poses a danger to the community, and his blood alcohol was 0.17. And it's at least a fourth DUI, Your Honor.
so you have to, for pretrial, if I just order the tab, do I also have to do the level of monitoring, or does that cover it for the tab?
It is possible for you to do a TAD with a GPS. In that insert, the defendant will wear 2 monitors. If you do TAD and a standard release, then he will only wear the TADs.
Okay, thank you. I just wanted to make sure. All right, Mr. Billy, the court does find probable cause, and as to count 1, I'm gonna set the bond at $5,000, but in addition, a level 2 GPS, no, strike that, a standard pretrial supervision with the TAD monitor. Okay? TAD, transdermal alcohol detection device. Good luck, Mr. Billy. Mr. Cox, thank you.
Your Honor, as far
Thank
as
you, Your
the
Honor.
request, that there not be any driving until further notice of the court, it does appear that his license has been permanently revoked.
Well, Mr. Billy, Mr. Cox, are you still there? Hung up. Well, Mr. Billy, you understand that your license is permanently revoked, so there should be no driving. Okay, thank you. Oh, you gotta put your, oh, I'm sorry, I did, because, Mr. Billy,
Yes, ma'am.
were you saying something?
What, yes, ma'am. What is my bond?
It's 5,000 on count. 5,000 on one, on the DUI, and 25 on count 2.
Okay, thank you.
And Your Honor,
Okay.
just for record, Mr. Billy, wait. Just for record purposes, I imagine since you're imposing a TAD monitor, that there's an additional condition, no alcohol or intoxicants.
No alcohol, no intoxicants, no driving. Do you understand,
ma'am.
Mr. Billy?
Yes, ma'am.
Okay, good luck, sir.
Okay, thank you.
Paul Henry Lupien.
Here, I mean, Judge Kuchin.
Mr. Lupien, you're before the court today for count 1 of a petty theft, and count 2, there's a felony capias. The court does find probable cause. My notes indicate that you should be going to your felony court tomorrow at 8:30 a.m. So the bond at $25 on count 1 remains, and you'll be before your felony judge tomorrow. Thank you.
Thank you.
Shane Dylan Bailey.
Bonded.
Todd Arthur Godfrey.
Bonded.
Yoan Cesar Contreras.
Bonded.
James Stephen Anthony.
That'll be a medical reset, Your Honor.
Okay. Barry Lamar Williams. Ms. Broward,
Be asking for pretrial release on Mr. Williams.
can I hear from the state of Mr. Williams? Good morning, Mr. Williams. You're before the court for count one, a grand theft. Your attorney has indicated that you're asking for pretrial release. I'll hear from the state.
One moment, Your Honor. Ask the bond to be kept in place. Emphasize.
Your Honor, the state is requesting that the bond be kept in place, as well as the defendant has in 2018. And Your Honor, also 5 previous times the defendant was caught on video surveillance for the same or similar crime, as well as in 2018, he had a petty theft. In 2018, he had a resisting without violence. In 2011, he had a petty theft. In 2012, he had a burglary and a grand theft. In 2011, a failure to leave the property upon an order. 2009, a burglary, possession of burglary tools, and a petty theft. 2008, tampering or fabricating evidence and possession of cannabis. And 2002, he had a possession of cannabis and possession of use or drug paraphernalia.
Thank you. Mr. Williams, the court does find probable cause. Your bond will remain at $1,000. And Mr. Williams, no return to Lowe's located at 1001 West Oakland Park Boulevard. Good luck, sir.
All right, I'll call your mom for you, Mr. Williams.
Yeah.
David Dwayne Bozeman. Good morning, Mr. Bozeman.
Good morning.
So you're before the court for grand theft, and the court does find probable cause. Mr. Bozeman, your bond is set at $1,000. Good luck, sir. Wilkins Stanley in Elian.
He's here present, Judge at Maine.
Good morning, Mr. Inalian. You're facing charges of count 1, possession of cocaine, count 2, possession of cannabis, 20 grams or less, and count 3, possession of drug paraphernalia. I have reviewed the probable cause affidavit and do find probable cause.
Judge, the only thing we're going to be asking is if we could check to see if his bond's been posted.
Okay. I've been informed that it's not yet been posted. The bond imposed is $1,000 on the possession of cocaine. The court will not impose a bond on the other 2 counts. Good luck, sir.
Thank you, Judge. I'll call your girlfriend right after court to see what's going on.
Farius Tanner.
Mr. Tanner's here present.
Oh,
Judge, he declined to serve as a public defender.
okay.
Yes, Judge, he has Michael Weinstein as his attorney. I contacted their office. They did not get back to me as of yet.
Okay, confinement status has an announcement. On counts 3 and 4, what? Yes? Uh-huh. He has court tomorrow? Okay,
Yeah, that's what I was gonna say. Judge Siegel signed the transfer order specifically for his hearing for tomorrow morning.
okay, thank you. Okay. All right, Mr. Tanner, you do not wish to have an attorney represent you at this time?
Yeah, he can.
Mr. Tanner?
Oh, I thought, he refused, the services. Did I hear wrong?
I ain't refused. I just told I had an attorney.
Oh, that's right, you do.
Okay, well, we're
So,
not gonna be
Mr.
here
Tanner,
tomorrow.
I do find probable
I
cause,
can tell you
and,
Mr. Tanner has court tomorrow morning in front of Judge
I'm told
Siegel.
that you have court tomorrow. Does your attorney
Yes.
know that?
I don't know. I
He
just
does
got
now.
here.
He does
I'm on
now?
the phone with with Mr. Weinstein's office right now.
Okay, thank you very much. So then,
Oh,
at
all
this
right,
point in
Judge,
time.
Mr. Weinstein can be here within a few minutes.
Okay. Mr. Weins, your attorney is on his
Okay,
way.
thanks.
We'll recall your case when he gets here.
All right.
All right. Last name is Chinye, Chinye. I won't attempt to try to pronounce the first name,
Chinye, okay.
because then I will butcher your name. So Chinye is Mr. Chinye, good morning. You're before the court today on one count of grand theft. Count two, fraudulent use of an ID of another person without consent. Count three, defrauding a financial institution. Count four, illegal use of a credit card. 5 and 6 are felony violation of probation matters. The court does find probable cause. The bonds for counts 1, 2, 3, and 4 will remain, and I don't have a date when you'll be going to your felony probation judge.
Judge, I believe there's VOPs from Palm Beach. Considering he
Okay,
has no bond holds, nothing to add at this time.
okay, thank you. Did I see Mr. Shade? There was one case, I believe that was yours.
Ms. Jameson, Judge, on page 1?
Yes.
I understand, Judge, she went back. She didn't,
Oh, they sent her back?
they sent her back. Or she decided to go back.
Oh, okay.
She had other things to do.
So,
She was okay, she just decided to go back. So, Judge, I don't know if you want to put on the second look for this afternoon, or the afternoon docket, or roll for tomorrow.
are you gonna come back to this
I'll be
afternoon?
here this afternoon.
Okay, then we'll reset it for this afternoon.
Okay, perfect.
Thank you.
Thank you.
Okay, what were we doing with Mr. Tanner? I've put it to the side now.
Mr. Weinstein said if
Oh, that's right, he's coming.
gonna come right over.
So Carlos Barbosa,
Bonded, Judge?
how about Chezun Jamar Murray?
Mr. Murray, come on up, please. He's approaching, Judge.
Good morning, Mr. Murray. Mr. Murray, you're before the court for trafficking in heroin 20 grams or less than 30 kilos. The court does find probable cause. Does the parties wish to be heard as to bond?
Yes, Judge, first question, is this a new law offense, or is this a change of charge KPS?
This is the new law offense.
It's a new law offense. It doesn't say add charge or anything.
When was the date of incident on this case, Judge?
It was after he was out of custody on his pending trafficking of fentanyl.
January 23rd.
Thank you. Judge, Mr. Murray, there's no way he's gonna be able to afford $500,000 bond. From what he tells me, unfortunately, he's homeless at this time. He works, for a labor pool, so whenever he can get work, he gets paid anywhere from $60 to $100. He owns no property from what he advised me. So, Judge, at this time, this is, something he cannot afford. We'd ask you to take that into consideration.
All right.
Your Honor, the state is not seeking any modifications, and that the bond be kept in place. He faces, if convicted, 25 years minimum. 25-year min-man.
Thank you.
And he's out on trafficking fentanyl,
He's out on what?
trafficking in fentanyl.
Sure, you're on, and it's, 1 moment. And Your Honor, just so the court's aware, he's out on trafficking fentanyl between 28 grams and less than 30 kilos, which also carries a 25-year minimum mandatory prison sentence.
Thank you. The court does find probable cause, and the bond is set at $500,000. Good luck, Mr. Murray. Brandon Javon Gardner.
Mr. Gardner's here present, Judge. He has private counsel Mickey Roque.
I left a message for Mr. Roque, Judge. I had not heard back from him as yet. Just give me a chance. Let me try calling him again.
All right, Mr. Gardner, I can recall your case. We're trying to see if we can find your attorney.
In the case that I can't, can I use a public defender instead?
That's your choice, sir.
All right. Oh,
Okay.
thank you.
Jason Christopher DeWild.
Mr. DeWild is here present, Judge of Maine. Come on up, sir.
Good morning, Your Honor.
Good morning, Mr. DeWild. You're before the court today for possession of cocaine, expired tag, less than 6 months, and there's a traffic, a KPS. The court does find probable cause.
Judge, can we check to see if his bond's been posted?
His bond was posted? Okay, we're checking, don't. Not yet, but, DEWILDE. It's not been posted yet. The court will, leave the bond at $1,000 and, everything else remains. Thank you. Danielle James Dunkelberger.
Mr. Duncanberger, come on up, please. Who's approaching, Judge?
Good morning,
How you doing, Judge?
Good morning. I'm doing well. How about you?
I've been better.
I hear you. You're before the court today for count 1, possession of cocaine, count 2, drug paraphernalia. The court does find probable cause. Your bond on count 1 is $1,000. Good luck, Mr. Dunkelberger.
Judge, actually, Mr. Dunkelberger is going to be asking the court to consider releasing him on pretrial release. He's 28 years old. He's on disability. He got $771 per month. He lives with his father. His father's retired. He gets Social Security. And Mr. Dunkelberger advised me he does not think his father can afford a bond. Judge, considering this is a nonviolent offense, we're going to be asking the court to consider releasing him on pretrial release.
Does the state wish to be heard?
The state has no objection to that, Your Honor.
Okay, then Mr. Dunkelberger, the court will, release you to pretrial supervision. And I'm adding random testing.
Have a great day.
Thank you. You too.
You need to report there as soon as you get out, okay?
David Akeem Burton.
Mr. Burton is approaching. Come on up, sir.
Hello.
Good morning. You're before the court today on driving while license suspended, third or subsequent offense. And then the second count is a traffic infraction not for magistrate.
Judge, before I get into his ties, I'm gonna see if the state is gonna be objecting our request to place him on pretrial release. I didn't even know that.
Your Honor, the state has no objection.
All right, so Mr. Burton, the court does find probable cause and will release you to the pretrial supervision, standard pretrial supervision. David Paul Mack.
Mr. Mack is here present, and he declined the service as public defender, Judge.
Mr. Mack, you're before the court today on aggravated battery on a person 65 years of age or older, and count 2, a touch and strike battery. You have the right to have an attorney at this time. Are you declining the services of the public defender?
Yeah,
Do you have a private attorney?
I think we're going to purchase one.
You're going to get one. Okay.
Yeah.
All right. So then, Mr. Mack, the court does find probable cause. As to count 1, aggravated battery on a person 65 or older, the court sets the bond at $10,000. On count 2, the touch or strike battery, the court sets the bond at $5,000. Mr. Mack, you shall have no contact with Cindy Nadler or Ann Calhoun. Do you understand that, sir?
Yeah. Yeah. They put battery on me too.
All right. Good luck, Mr. Mack. Mr. Bernard.
Judge, he's in court. He's in room number 4750, Judge.
Your Honor?
Yes.
I can tell you, I spoke to, he's represented by Andrew Coffey. He was in court on this case yesterday. It's a change of charge.
Right. Oh, it's a change of
It's
charge?
a change of charge from resisting with violence to battering a law enforcement officer. Bond was originally set at 1,000, and he had no objection to the court. And I was going to request that the court set the bond back at $1,000.
So is it, he's in court today, but will they address this?
I think he's in court on a different matter, because what Mr. Coffey told me, and I'll check to confirm.
Because my notes indicate he should be in court tomorrow at 8:30. I don't know. I'm just telling you what I have.
No, I know. He's scheduled for arraignment this morning before Judge McCarthy on this. If you want to put it on, if we could put it on a brief recall, I'll ask Mr. Coffey if he has any objection, if he wants to.
Okay, can you do that? Because I don't want to make a ruling on this
No,
and
of
he's in
course.
court on something else, on the same thing.
Of course.
Thank you. We'll recall Mr. Bernard. Dion Otis Gray.
Judge, Mr. Gray is here at Maine. He declined the service of public defender.
Good morning, Mr. Gray.
Good morning.
Mr. Gray, you're before the court on one count of fleeing with disregard for safety to other persons. Is this?
It's a change of charge, Your Honor. You actually heard, you had Mr. Gray appear before you yesterday on a murder case.
Okay.
The bond in this matter was originally set at $2,500. Just asking that the bond be set back at $2,500.
So this is a change of charge from the charge that he was here yesterday?
No, that was a separate matter. He was originally arrested on fleeing and eluding law
Right.
enforcement. It was upfiled to aggravated fleeing and eluding. Even though it's been upfiled, I'm still just gonna request that this same $2,500.
And the bond was $2,500. So, Mr. Gray, the court does find probable cause and the bond remains at $2,500. Good luck, sir.
All right.
Javon Springer?
Mr. Springer, come on up, please. He's approaching, Judge.
Mr. Springer, you're before the court on a felony probation violation, battery on an officer, and resisting officer with violence. My notes show that, Mr. Springer should be going to court tomorrow, at 8:30 a.m. on the felony matter, on the felony VOP. So, is that why, okay, so I have this handwritten 1 and 2, which is what I read, the battery on the officer and the resisting officer?
Yes, he needs a bond on that. He's back from the hospital.
Okay, all right. Then
And Judge,
yes.
those two offenses are third-degree felonies. I do realize this is kind of academic because he has a no bond hold VOP. We're gonna be requesting $1,000 on each count, on 1 and 2.
And, Your Honor, considering the fact that he's on probation for resisting with violence, he was placed on 2 years probation December 18th of last year, and based on the level of violence alleged in this matter, I'd be requesting a $2,500 bond on 1, $1,000 bond on 2.
Thank you. Considering that is already on a no bond hold, the court will impose on counts 1 and 2 $1,000 bond on each count.
And, Your Honor, if it please the court, we can recall Kalfani Bernard.
Kalfani Bernard. Can we recall Mr. Bernard? Is he still there?
No, he was the gentleman that was in court, Judge?
Oh, yeah. Okay, so I just got off the phone with Mr. Coffey.
Yes.
He'd already filed a written plea of not guilty previous to today.
Okay.
I understand it shows that he's scheduled for arraignment. Mr. Coffey wasn't gonna be there, but what he did advise me, as an officer of the court, he has no objection to waiving his appearance.
Okay.
For this first appearance, having the bond set at 1,000. He's going before his judge next Tuesday on this matter anyways.
All right. Based on the representation, the bond, the court does find probable cause and the bond is set at $1,000. Thank you. Brandon Lee Cunningham?
He's here, present, Judge at Maine. He is approaching. Come on up, sir. Yes, ma'am.
This is,
Perfection. I have no additional information at this time, Your Honor, so he is entitled to an ROR on counts 3, 4, and 5.
all right. This was set for perfection. Was that what I had yesterday? 3, 4, and 5. All right. Then, no probable cause. Oh, let me sign it.
Yesterday, Judge, Mr. Cunningham just wants to know, he was here yesterday, what was just the bond amount for yesterday's offenses?
Because I couldn't.
That I don't remember. I sent, it was for, do you have it?
I have it here. It looks
Okay.
like it's $19,600 on the ag assault, delivery of heroin, resisting without violence, and fleeing law enforcement.
Thank you, Judge.
Which one is that? Oh, okay.
Put counts next to it. There's no PC on it.
3, 4, and 5. Thought it was somebody's trying, I read it and I was like, there's no change. What? This is a test? All right, so we are waiting on 2 attorneys for Brandon Gardner and Mr. Tanner.
Yeah, I did speak with Mr. Roque. He's going to be calling me back shortly, I hope.
Mr. Romero, do you have anything else?
No, I'm fine.
Okay.
Thank you, Judge.
Thank you. We're waiting for Mr. Roque and on Mr. Gardner. And Mr. Bernard, no. What about Mr. Bernard? Which one is that?
He was next to the end.
Do you have it? Oh, yes, we,
did have?
yes.
It's $1,000 on the count on the bill. Thank you.
Yes?
Has been in touch with Mr. Weinstein. He is asking for Mr. Tanner's case to be reset for Monday.
Till Monday.
Is that the case that's going in front of Judge Siegel tomorrow?
Is that on which one?
Then there's no reason to reset it for Monday.
Well, I don't know, because I guess on the misdemeanor KPS, he set for court on the 28th. Is that Monday? Is that why that's why he's saying that? But he's got.
28th is Monday.
But then you said on the felony, he's got court tomorrow.
Yeah.
Does Mike actually want these reset to Monday?
Well, whether he actually. Well, that's what I was gonna say, even practicality aside, legally, you can't put off his first appearance till Monday.
Right. So,
I'll give you my cell, but we get such poor reception in here that I can't
Unless it's like medical or something.
Judge, yes? I'll let you know right now. Judge, Mr. Weinstein is aware. Mr. Weinstein is aware that Mr. Tanner has court tomorrow on his misdemeanor charges, but he is asking the felony cases to be reset until Monday.
He has court tomorrow on the
he has
felony.
court tomorrow on the felony
He has court
cases.
tomorrow, he has court tomorrow on the felonies.
So as to Mr. Reedy, just let him know, this is for first appearance. I have find probable cause, and I'm not going to make any changes on the KPSs and the felony charges. There is $1,000 on each count.
Okay.
So he can deal with it.
Oh, okay, all right. Well, the judge just found probable cause and left the bond at $1,000 each count. Yeah, I don't know.
Mr.
It looks like
Tanner?
no bond holds on these misdemeanor
Yes.
and traffic citations,
Yeah.
though.
Mr. Tanner, we have your attorney on the phone, Mr. Weinstein. And I'm also told that you should be in court tomorrow on the felony cases. And there's a pending court date on the misdemeanor case. So the court does find probable cause with your attorney on the phone, and we'll leave the bonds as they are, okay?
That's it.
Thank you. And then we've been waiting for Mr. Roque. I'm going to reset Mr. Roque's case to the afternoon.
Can I just use PD? Can I just use it?
So, Judge, I just told Mr. Garner that his case is reset for this afternoon.
Thank you. On Mr. Gardner?
Yes.
We're gonna reset him to the PM.
Yes.
Thank you. Thank you, everyone. We're at court's in recess.